Thank you, Mr. Mkhize. Thank you, Mr. Bukula. I also support. Can't see other hands. Thank you, Ms. Mpungose. Not sure. I can't see Advocate Sithole. Thank you, Advocate Sithole. All right. Thank you very much, members. The declaration of interest forms have been uploaded. If you could kindly remember to complete the form and submit it to Mr. Eliezer Dlamini before the end of the business day today. Members, we are going straight to the substantive items on the agenda. We're going to start off with item number 5, which is the final assessment of Sasol Gas's amendment application for the maximum price of gas starting from 1st July 2023. Please introduce the item.
Thank you, Chairperson. I will introduce the item being assisted by the EM and also the colleagues that has been working on the application. This is the application from Sasol Gas, and it is for the amendment of the amendment application for the approval of maximum price for the period of 1 July 2022 to 30 June 2023. Sasol Gas, in this application, it submits that it's been charging a maximum price of 68 Rand per gigajoule since FY22. According to Sasol Gas, the maximum price of 68 Rand was as a result of the engagements it had with NERSA to keep the price at this level in response to the surge in the international gas price. You will recall, Chairperson, that since immediately after the 2021 decision, there was a surge in the international gas price. And the maximum price was kept constant and not adjusted by Sasol Gas. And therefore, Sasol Gas submits that it has suffered financial loss during the FY23 period and requires to be compensated for the loss, hence its application for the maximum price amendment. According to Sasol Gas, one of the exceptions to the common law rule is that the decision can be revoked with the consent of the person who benefited from the decision. And therefore, Sasol Gas believes that its application is based on the common law rule. It is therefore in order. Now, we have summarized the Sasol Gas application on table 1 of the submission under paragraph 4.2. They are asking for the weighted average price of the 120 Rand 32 to be applied retrospectively. Chair, in terms of our assessment, we started by assessing the legality or the jurisdiction of this application, and we believe that the application is flawed because of the following 3 reasons. The first reason is the fact that NERSA does not have powers to amend its decision, meaning that the NERSA decision of 31 March 2021 is still valid until set aside by the court. And secondly, we believe that the application is flawed because the Sasol Gas uses a methodology that was approved in 26 January 2023 to amend the price to be implemented in the period of 01 July 2022 to 30 June 2023. We believe that the methodology approved in January 2023 cannot be implemented retrospectively, and therefore it makes the current application flawed. The third reason is the fact that the elements included in this application are not accommodated in the methodology. The elements such as the value dilution and also opportunity cost, those elements are not included, and therefore it makes this application flawed. Chair, as part of the assessment of the application, we also recognize that indeed Sasol Gas may have had experienced increases in cost that had not been catered for in the maximum price that was kept constant in FY 2023. And therefore, we believe that the appropriate mechanism to deal with the cost increases is through a clawback mechanism, and this mechanism is catered for in the methodology. Chair, we also received stakeholder comments and also a public hearing was held regarding this application. Most of the comments, especially from traders of gas and also the association IGWASA, they agreed with the NERSA discussion document that was published for comments. For example, IGWASA is saying, which represents some of the large gas users, they believe that the application is indeed flawed. And further on, they indicate that in light of the pending review application before the High Court, it is impermissible at this stage for Sasol Gas to apply for an amendment of the application. And some of the traders believe that there is no merit in the application as it is flawed and in conflict with the common law principle. We are asking the committee to approve the recommendations that are on paragraph 14 on page 19. Thank you, Chairperson. I will ask my colleagues to also add.
Thank you, Ms. Makota. Is there anyone who would like to add something to the introduction made by Ms. Makota?
Maybe, Chairperson, just quickly to come in and add and clarify the aspects that pertain to the challenge that really we had on our side with regard to considering this application for approval. Number one is that it is a well-established rule of law and part of our jurisprudence that once NERSA has made a decision, it cannot go back and basically, change that decision because it's commonly considered to be functus officio. So that was the first challenge. And what Sasol is seeking to do with this application basically is to request NERSA to go back to that decision that was made in 2021 and amend it, as they put it, to basically change the adjustment that was determined as part of the decision. But NERSA cannot do that because NERSA simply does not have the jurisdiction and the legal competence to change its decision once made. The second one, as Ms. Makota indicated, is with regard to the retrospective application of the decision. NERSA's decisions are made going forward to apply prospectively. They are not meant to actually apply retrospectively. The only instance where NERSA can actually make a decision or NERSA's decision can be made to apply retrospectively is if a court of law has made a specific decision. I think members might recall that in the Constitutional Court decision, the Constitutional Court did determine that the next decision that NERSA would be making would actually apply retrospectively. That was specifically to address the circumstances in a challenge that the Constitutional Court had identified, but that determination can only be made by a court of law. NERSA does not have the legal competence to do that. Chairperson, I think I just wanted to add those two aspects in clarifying the position with regard to the challenge that we had. Thanks.
All right, thank you very much. I thought also you would balance the introduction, the issues here, so that it's not one-sided, given the factual matrix of this case, which is the fact that there is a decision that allowed Sasol to adjust its price, and that is the right that was given by the regulator in terms of its decision that the licensee must adjust its price, and NERSA still stands by that decision, but the licensee could not because of the issues that arose, and it was just trying to be sensitive. So that aspect is also very important. So it meant that the licensee could not recover the revenue that it was supposed to recover, meaning that there was still a valid decision up until June of this year. And now we are faced with a situation where we need to make sure that the revenue that is lost, or the shortfall in the revenue, is recovered. the team is talking about the law back in that respect. So I thought that you will also just balance it, because the law requires us to take into account the interest of all parties, of all stakeholders, that is in terms of the law. So it's important that we sort of present a balanced story. I thought you will touch on that aspect, so that the historical context of this matter, the members are apprised of it. Members, having said that, I just wanted to add that aspect, to say that there was a decision, but they wanted to also just be guided by NERSA at the time, just to be sensitive of the issues that arose at the time. The submission is before the members for the guidance and the comment of the members. By show of hands, members, if you have any guidance under these circumstances on all the issues that were pointed out. Mr. Mkiza, may you please go ahead?
Thanks, Chairperson, and thanks for the presentation. It's a bit difficult to really understand some of the things with Sasol, looking at the size of the organization, to say why what was it was the fact ignored, if I may ask? Because I don't think that in the submission there is actually the good capturing of Sasol's argument. Even presenting now, it just states that this is common law, and then the argument also coming from the other stakeholders also cites common law. But as to really argue the fact that we cannot, there is this functions official principles that we may not violate, and if you would expect that there would be that understanding. But in terms of why Sasol Gas chooses to ignore that, because so when one goes to the to table 4, you kind of get an understanding that Sasol Gas considers the adjustment that was done at the based on the determination by NERSA as the basis for them to do the same here. And I think that in the submission there should be a clear delineation or separation of the two in terms of them not being the same, because it appears to me that the argument is along those lines, and also to say what recourse do they have from their side. Let's say if you were to make a mistake in your tariff application, for example, what recourse as a licensee would you have to address that? Because I think for me it would help to get that point across clearly, just to understand that there wouldn't be comebacks on this matter. And then on table I think is the executive summary. If they think when it comes to the lodgement of the application, like you when you say that on 30 June 2023, Sasol Gas reverted for the energy regulator to proceed with its processes. I think it should just be clear as to what are those processes. It doesn't make it clear. And my understanding is that this is still pertains to financial year 2023. It's not financial year 2022, just to make sure, if my understanding is still for the current financial year, that they want us, that they have a tariff and they want to, the price, and they want that to change that price. That is all really from my side. It's just to make it clear what the argument for the licensee is and how our argument is, and that the previous decision and this decision are not the same. Just to articulate that very clearly. Thank you.
Thank you, Mr. Mkhize. Mr. Gomet?
Thank you, Chairperson. Good morning again to you and the members of management. Chair, for me, I think just one question of clarity. I think the and I'll read just about guidance from this functus official principle for us that simply says, is it not possible for an applicant, if there is one decision that has been taken on review whilst they're still before the courts, for the applicant to then, within the processes, within NERSA processes, to submit another application that might be different, and therefore not necessarily seek us to change our own decision, but to seek that we have a different decision, whilst the other decision may be taken on review. Is that not a possibility? I guess what I'm trying to get at here, Chair, is it not prudent? Is it not a prudent approach to then say, whilst the courts may be dealing with or reviewing an old decision that has been taken on review, that perhaps if the applicant themselves or somebody else may have seen an error and may have then resubmitted something, that the regulator can then still deal with? Yes, you may end up with two decisions, but it's not decisions on the same applications. It's not two decisions on the same application. So it would be a decision, perhaps, that could be, it would amount to a new decision. So I don't know. I'm just trying to understand, Chairperson, here, whether is there no space for NERSA to for the survival of the company or the industry, that if one decision is being taken on review for whatever errors that may be there, that if on application by the applicant, that a new decision can still be made. Thanks.
Thank you, Mr. Gomet. Can we get responses from the team? And also legal services, you've been part of this work from the beginning. Can you also just come in and clarify the legal questions?
Chair, I will start and then I will also ask the legal advisors to come in. In terms of the first question from Mr. Mkhize, to say that we should clearly indicate Sasol Gas argument and also our own analysis, I think we shall do that. And then part of that question, he also asked, what recourse do they have to address the mistake that they have made on the tariff application? Chairperson, there is a section in the draft RFD which clearly talks to what to do in cases of a price adjustment or in cases where Sasol Gas wants to apply for a clawback to cater for the differences that were experienced between the time of the application up to now. And therefore, we are saying that in terms of the recourse that they have, they need to submit a clawback based on the methodology. And in submission that clawback, they need to have the audited results, the audited actuals, so that they are able to indicate to NERSA what cost increases they have experienced. And then NERSA will then apply its mind based on the cost increases and the evidence that has been provided. Chair, the other questions really are of legal nature, and I will ask the legal advisors to come in.
Do we have Ms. Mvuyana? Because time is running out. Members don't have the whole day. Ms. Mvuyana and Mr. Mashian.
Good morning, Chairperson, and good morning, everyone. Yes, on the question, I think the question raised by Mr. Gumede is also related to the certain aspects of the question that came up from Mr. Mkhize's question, that being the question of whether it is possible for a person to approach the regulator for a second decision decision while the first decision is being reviewed by the High Courts. The general principle of law is that for as long as the decision, the administrative decision that was previously taken is not yet set aside, it remains valid. So therefore, it would not be prudent for the energy regulator to revisit the matter or hand down a second decision in respect of the same subject matter, that being the maximum price that should have prevailed during the FY 2023, while the matter is not yet finalized before the High Court, because the risk there is that if it should happen that the outcome of the High Court application would be to say that previous decision still remains valid, and NERSA has now entertained a second application and issued a second decision, then there would be a difficulty to say which of the two decisions, which most probably would not be the same, which of those two would have to prevail. So the common rule in this regard is that you follow the first decision until it is set aside. You as the administrator or the decision maker, you cannot issue another decision, because if you can do that, then in law it means the second decision is automatically invalid. So the first decision is the one that will prevail until it is set aside. Thank you.
Can you please just to clarify things so that when we talk about legal principles, and then we can apply the facts of the case once we articulate the principles, legal principles, and then apply to the facts of the case. The decision that we're talking about here, or at least the part that Sasol is concerned about, is only the adjustment. The decision that we are talking about is the maximum price for a period of 2 years. So for the first year, the price was implemented, and there was no problem about that. So the sort of escalation or the adjustment was supposed to then kick in for the second year, which was then July of 2022. That is the part that could not be implemented. The part of the decision is not the entire decision. It is the part of the decision that could not be implemented. That's the first thing here that we must focus on. And the second one is this, that the reason it was not implemented is because remember that the regulator had to make a decision based on economic data, like a sort of a forecast of the economic data for the adjustment. Now, that information that the energy regulator relied on did not materialize. That economic data changed significantly, and therefore those assumptions could not materialize. Otherwise, they were going to result in absurd outcomes. So then Sasol could not implement that second part of the decision. So I guess to try and articulate that legal principle that Mr. Gumede asked, one has to then apply the facts to ask, if then somebody submits in an application with a different set of facts, because the economic assumptions could not materialize and they were going to lead to perverse outcomes. Now, with a different set of facts, for that adjustment, would that still temper with that issue of what you call of not being able to revisit your own decision, because the facts are different here? So can one clarify that aspect right now? So that is the aspect, that is what is all about. And apart from the sort of the format and the scope of the application for now, just that part to be able to respond adequately to the question that Mr. Gumede asked.
Chair, I will attempt to respond to that, but I will also ask the legal advisors to come in. Chair, when we did a rationality test in 2021, we realized that the adjustments that NERSA had approved was no longer competitive, in that the price was increasing very high. And therefore, the advice that was given to Sasol Gas was that they need to apply for an adjustment of the maximum price, meaning that we can no longer adjust the price based on the international benchmark, as those adjustments which are related to the international benchmarks, they were not related to cost, and they were giving results that were really irrational. And therefore, the results results were that the prices was increasing excessively, and NERSA could not allow that. Hence, the advice to Sasol Gas to say, because NERSA had approved a base price which was supposed to be adjusted on an annual basis, the best thing to do is for Sasol Gas to apply just only for the portion of the adjustment of that price. Now, when Sasol Gas applied for a price to NERSA, in the application, we realized that they did not follow the NERSA advice. They then applied for a price that is as if there was no decision that was taken in 2021. If you see the application that on page table 4, of the summary of the application, you will realize that they are not only applying for the adjustment, but they are revisiting the price. And it is on those bases that we are saying this maximum price is flawed. However, had Sasol Gas applied only for the portion of the adjustment, the application would have been considered as part of the clawback mechanism, which allowed for price adjustment or price increases to be attended through as part of the maximum price application. You will recall that in the formula for the determination of that maximum price, there is a C there which takes into consideration the differences in the adjustment of the price. Chair, I will end here and I will ask my colleagues to also add.
Mr. Kumede, and also inviting the legal people to clarify that aspect, please, so that we are focused here, and then the questions must just be answered adequately from the members. Mr. Kumede?
Chairperson, just to add perhaps to the clarification, and thank you again for clarifying my question. But for me, I think the question that remains in my head is that for the possibility of the court to arrive at a different decision to other than that may have been sought to declare a particular NERSA decision, or rather to actually review a particular NERSA decision, is for parties to then oppose it. The question that I may ask is that, in respect of the case that we have at the moment in terms of the review, are there any parties, including Sasol itself, that might be opposing the reviewer decision? The concern, I think, Chair, that I have is that yes, I understand that we can't revisit our decision, but in the event that we made an application to the High Court and the matter is not handled as an urgent matter, and maybe we only get the matter heard after 2 years. The question, I think, if NERSA doesn't have an alternative manner of coming up and working out a different decision, whilst another matter may be, or whilst an old decision may be before the High Court, especially if it's not really contested by ourselves, is that we may find ourselves with a vacuum where there's a decision that is in the High Court. We can't make a new decision even based on a new application. Then is that not exposing NERSA and exposing the applicants as well. So I think I'm just extending on the question that I had posed earlier. Thanks, Chair.
All right, thank you very much. Can I have responses, and we are going to try and now summarize to get to the decision. So clarify these questions, but also the fact of the matter is that even the application as it stands is an amendment. So obviously you can't, if you were to apply based on new set of facts, this is an amendment. It's not necessarily a new sort of a new application just for the adjustment. So the scope of it also is a problem. So either way, the application that is before us in terms of the scope, number one. So just to try to assist the members to getting to to narrow the issues. So the scope of the application is already an issue here. And then the second thing that members need to note is that SASOL applied using the new methodology that the energy regulator approved in January 2026. So if SASOL was trying to fix the adjustment of the decision or the adjustment of the decision, which used a different methodology, it could have adjusted the price even automatically, but not excessively. The only issue that we had a concern with was to take advantage of a surge in prices. If it has limited its adjustment and not take advantage of the windfall profits arising from the shocks, the demand shocks and the tightness of supply internationally, we would not be where we are today. So that is the second thing that the members need to understand. They used a methodology that is now a new methodology, not that very same methodology, and then apply rationality, which is also part of that methodology. So that is the problem here. And then the third thing is that there are three options. One option is the one of the clawback, if one looks at it, the one of the clawback. And then the second thing could have been the adjustment, but the adjustment must not be an excessive adjustment. That's all that the energy regulator has indicated. Now, to come up with a new application, this is an amendment, it's not even a new application. That is the first thing. And then the other thing is that they used a new methodology approved in January of 2023. So those are the challenges with this. So either way, all of those things, when we take a decision, we must apply them to the decision that we're going to take at the end of the day. Mr. Mkhize?
Thanks, Chairperson. I don't want to delay the meeting. From my side, because I support the recommendation in terms of us not violating the features of official principle. But I was just talking about being comprehensive in dealing with the matter. I understand the issue of the clawback. What I'm saying is, if an applicant would not wait for the clawback, do they have any alternative? Just to include that aspect. I'm not saying that they should give me an answer here and now, but that aspect should be included to say what other avenues do they have instead of applying for an amendment, which we cannot be able to allow. I'll leave it at that. Thank you.
Thank you, Mr. Mkhize. Mr. Mvuyana, can you please respond? And Mr. Ngumalo, all of the legal people, can you please assist the committee here to come to the decision?
Thank you, Chairperson. I'll try to provide a brief response. The only alternative that I currently know of would have been the clawback. So, as Mr. Mkhize is suggesting that perhaps we do not have to have a clear-cut answer right now. if the clawback mechanism is not working for the applicant, what other alternative could work? Perhaps we can go back and also look into that, but I do not have knowledge of any other alternative that we have. As for the amendment, the difficulty with that one is that even in terms of the Gas Act, we do not have the power to amend our previous decision or part thereof in respect of maximum price approvals. Thank you.
Any additions, Mr. Ngumalo?
Thanks, Chairperson. I think just to add one or two additions in relation to what Social Gas has proposed from their side, and I think members might remember some of this from the public hearing. They proposed 3 possible avenues in terms of which NERSA can possibly look into this decision as an alternative going forward. The first one, they said that NERSA can basically conduct a rationality test. That's number one, to test whether the price, the maximum price that Social Gas is proposing is actually a rational and reasonable one. And using that rationality test, NERSA can perhaps take a decision. The second avenue that they proposed was to say NERSA can revise the adjustment. And in revising that adjustment, I think they were being specific in relation to basically the adjustment element itself, not the entire decision, but the adjustment element. And this is where then they raised the argument that that adjustment was actually aimed at Social Gas as the beneficiary of that particular decision. And the argument they then raised was that to the extent that as the beneficiary of that decision, they would have agreed, or if they agree, to NERSA basically changing that adjustment, they felt that on that basis, NERSA can be able to basically derive a mandate or jurisdiction to basically consider that adjustment and specifically the adjustment. The challenge with that lies in the fact that under Section 10 of the NERSA Act, NERSA has to follow due process with regard to making a determination or deciding on any application. And part of that due process really entails and involves seeking comments from stakeholders and basically testing the views of other parties within the industry as to what those parties are saying. And if members might recall, during the public hearing, IGWA SA in particular and others were quite vocal in this with regard to the potential challenge of this, to say they are also affected by that very adjustment element. So it would be basically not proper to say the sole beneficiary or the only beneficiary of that adjustment was SOSO, and therefore if SOSO agrees to it, then the others do not need to be considered in terms of their views. And I think IGWA SA came out very, very vocally to say they are equally affected as part of the industry, and they made that input that they would have a problem with regard to that. Chairperson, I think the last avenue that they proposed was to say NERSA then can make a decision in terms of its powers to basically say, if Social Gas has not proposed, or if NERSA does not agree with the maximum price that Social Gas has proposed, NERSA can then make a determination itself to say this would be the price that would be appropriate for NERSA to, or for Social Gas to basically utilize going forward as a maximum price. So those are the aspects that were proposed from Social Gas's side. And I think to the extent that, then Chairperson, in line with your earlier request, we can enhance the submission to basically include those going forward so that it can clarify exactly what was requested from their side.
Is that part of the application, Mr. Ngumalo, or are you talking about the things that were discussed before? Because, for instance, the last point that you made, that Sasol said we can proceed with we can follow our processes the way that we do. That specific correspondence, I know the content, and I responded to it. All that they were talking about there is the delay, and the delay is really not helpful, and the regulator must be sensitive to that, because it will prejudice the licensee. And indeed, when the applications before us, we are not supposed to delay them. So that specific correspondence was talking to the delay. All it was saying is that, NERSA, we've got nothing to add now on the application that is before you. Please continue with your processes and take a decision, not to determine what maximum price they are supposed to charge, because we made it clear in all occasions that maximum price was never set aside. It was still valid. The only thing that Sasol did not utilize in that decision was the adjustment, and we do understand that that might have affected the revenue of Sasol. That's all, and that is the reality, because it did not adjust. So that's number one. So all of the others, the application is the way that it is. It has always been like that since it was submitted in March of this year, late March this year, and also additional information being received in April of this year. So it was always an application that is an amendment to start off with. In addition to that, Sasol asked for elements or things that are not in any of the methodologies that were approved by NERSA, including the methodology that it utilized for this application. So those were the other additional things. And the third thing is that the methodology to cure a decision that was previously taken, you can't use a new methodology because you were talking about the previous decision. So that was also an issue. They could have just adjusted, but in a rational manner, which is something that it did not do, because they wanted to take advantage of the surge in prices. So, and then the third one that they were considering was the issue of the clawback. And NERSA indicated that that is the option under the circumstances, but it was not a decision of the team. The team was simply guiding what are the options that are available. I would like to give Mr. Pukula the opportunity. Mr. Pukula, I'm trying to narrow the issues so that we can get to the decision. Mr. Pukula, if you can come in, please.
Ms. President, apologies. In fact, what I wanted to input on is what you touched on. That's why you saw me dropping my hand very quickly.
Right. Thank you very much. Members, I think, first of all, I just want to indicate now whether members are comfortable with the recommendations. And the recommendations are very clear, because we can't have an amendment application, first of all. So the amendment application is out. So that on its own is an issue. And then the second thing, even if it was a new application, there is so I'm trying to summarize the points and also for the secretary to take that into consideration. The second thing that the team is saying is that even if it was a new application, not an amendment as it stands, that could have posed jurisdictional challenges, because NERSA cannot revisit its decision. That is the second thing. And then even if it was that new application, it would have been a problem because of retrospective application. That again is an issue of the retrospective application. Then the fourth thing is the use of a completely new methodology to apply on the previous decision that was taken by the energy regulator. Remember that the maximum price was still valid. The only thing, and they have implemented first part of it, the only thing was the adjustment. So they cannot use a new methodology approved in January 2023 for an adjustment that ought to have been done in July 2022. That is the other issue here. And then members, it's also important for the energy regulator to understand that the licensee has experienced the revenue shortfall that we can't run away with. It is our responsibility to make sure that it does recover the necessary revenue. Now, it has been a while that it has not adjusted its price, and therefore it is looking for guidance from the regulator and certainty as to how it needs to proceed. So it is still our responsibility to guide appropriately. And the team, therefore, on that aspect is saying to the regulator as part of this submission that there seem to be just a clawback, and even the audits will be done there. So it's a clean way, and there will be a clawback, and it will be, according to the team, a reasonable option to be taken into consideration. Hence, then, they made their recommendations. I would like to stop there, members, unless there is any other thing that members want to raise. But I summarized the issues and that are supporting the recommendations made by the team, and those are all the arguments that were raised. Members, are you then happy with the proposed recommendations, given the summary of the issues that are problematic in this application?
I'm
Okay,
covered. I'm covered. What I'm saying, Chair, they just need to do the enhancement accordingly, but I'm covered.
Okay, thank you. I think that all of these points they've touched on them. Maybe the only thing that they need to deal with is that issue of the process, which I also clarified. It was a correspondence that NERSA, please go ahead now. We don't have any other option that we can propose to you. Please deal with the application that is before you. That's what SASOL did. Deal with the application that is before you. Members, I would like to take you then to the recommendations. If there's nothing else members would like to add, can you tell me the page, Ms. Makot? Because I went to the other pages.
It's on page 14.
Okay, page 14. Okay, page 14, recommendation on paragraph 14.1. The pipe gas subcommittee is requested to recommend to the energy regulator to not approve Sasol Gas's amendment application for the maximum price for the period 1st July 2022 until 30 June 2023. For the amount of 107, and also if you note the difference in the amount there. And then the second decision that is required is that the PGS is recommending that the energy regulator approves that Sasol's amendment for the maximum price is not in line with the applicable legislation. I'm changing the words deliberately. Is not applicable with the, is not consistent with the applicable legislation in that it seeks approval for retrospective implementation of the maximum price. And then also the application uses a methodology that was approved on 26 January 2023, that is the year there. And then thirdly, the application included elements that such as inclusion of alternative value dilution compensation that are not included in the 2020 methodology or in the 2023 methodology. In the event that Sasol Gas intends to seek an amendment for 2023 decision made by NERSA, the established legal procedure for amending such a regulatory decision is by pursuing remedies through the appropriate judicial channels. Sasol Gas may apply for a clawback mechanism pertaining to its incurred cost, which contribute to the determination of the maximum price. And then the reasons for decision are attached on Annexure A. Members, those are all the decisions that are requested by the team. By show of hands, members, if you are comfortable with the decision and also taking into account just the enhancements that Mr. Mkhize spoke about. Otherwise, all of the issues are covered there. By show of hands, members. Thank you, Mr. Gumede. Thanks, Ms. Mbongose. Thank you, Mr. Mkhize. Thank you, Advocate Stole. I also support. Are you happy to support the recommendation to the energy regulator, Mr. Pukula? Thank you, Mr. Pukula.
Yes,
Thank
Chair.
you, members. Thank you so much. Thank you, members. We've taken a bit of time on this one, but it's understandable because all the issues needed to be clarified. We now move on to item number 6, which is the final assessment of Sasol Gas's application for a multi-year transmission tariff. Please take the matter as read and clarify the approach that has been taken by Sasol on this one and whether there are any contentious issues.
Thank you, Chair. Good morning, Chair, and good morning to members. This submission is for the final assessment of Sasol Gas's application for a multi-year transmission tariff for the period 1 July 2023 to 30 June 2025. This application was received on the 26th of April 2023. The application was submitted in line with NERSA's approved tariff guidelines. No comments were received from stakeholders on the application during the stakeholder consultation process, period. Table 1 on page 5, Chair, summarizes the application by Sasol Gas. Sasol Gas is applying for a tariff of R7.02 per gigajoule in Zone 1 in the financial year 2023-2024 and R24.89 in Zone 2 and R6.58 in Zone 3. And for the period, financial period 2024-2025, Sasol Gas is applying for a tariff of R6.93 in Zone 1, R25.51 in Zone 2, and R7 in Zone 3. Chair, it should be noted that the tariff in Zone 2 is higher than in Zone 1 and 3, and this is due to the lower volumes of gas that are transported in the Zone 2 area. The main differences between the NERSA and Sasol calculation, Chair, is in the weighted average cost of capital and the tax calculation that resulted in a difference of 0.46% for the financial period 2023-2024 and 2% in the financial period 2024-2025. The difference, Chair, in the work was as a result of the forecasted CPI used for the financial year 2024 and 2025. The difference in the work also then resulted in the flow-through tax calculation being different because the tax is calculated based on the return based on the work. Chair, on table 7 and 8 on page 8 of the submission, it provides a summary of the difference between the NERSA and Sasol tariffs per zone for the financial period 1 July 2023 to 30 June 2024, as well as for the period 1 July 2024 to 30 June 2025. The differences are less than 10%, Chair. It is a normal practice where NERSA would approve the tariffs, Chair, if the differences between our calculations and those of the licensee are within the 10% margin. Our recommendations, Chair, are on page 11, paragraph 14. Thank you, Chair.
Thank you very much. Members, the submission is before us. Any comments, issues of clarity from the members or some guidance on this submission? Are there any questions, members? Mr. Mkhize? You're on mute, Mr. Mkhize.
Oh, thanks. Sorry for speaking to a muted mic. Thanks, Chairperson and Melusi, for the presentation. Just like to draw your attention to page 2. I think the location should be the location of the applicant, not of the facilities, and to get that also addressed correctly there, just that matter. And then on page 4, it's related to all the applications actually, but I think it's more of a governance matter that given if we allow an opportunity for that at the end, Chairperson. Otherwise, I'm fine with it.
Okay, Mr. Mkiza, which one on the governance matter? Which part? Just the paragraph?
I'm saying the governance matter was, I think, was actually prompted by paragraph 4.6, but it's more of a governance matter. Yes, I would like it, and I think it applies to all of them. But I think it's more of a governance matter that I can just have a discussion.
Okay.
Yeah, once we've come to the end, if you allow that, Chairperson.
All right. Okay. Otherwise, are you comfortable with the analysis and the recommendation, Mr. Mkhize?
Yes, ma'am.
All right. Thank you very much, members. Any other member with comments? If none, I would like to take members then to the recommendations that are on page 11, paragraph 14. The PGS request or recommends to the energy regulator to approve Sasol Gas's application for transmission tariff for the period July 2023 until 30 June 2025, and also to approve the publication of the reasons for decision for the Sasol transmission tariff application, and then also to publish the RFDs. With confidential information being withheld. By show of hands, members, if you agree with the proposed decision. Thank you, Mr. Pukula, Mr. Gumede, Ms. Mpungose, Mr. Mkhize, and Advocate Sithole. Thank you very much. I also support. You have your decision, Ms. Makoda. Item number 7 is the final assessment of Sasol Gas's application for the maximum price of gas for the period 1st July 2023 until 30 June 2024, the FY24 maximum price application. Please introduce the matter.
Thank you, Chair. I will introduce the matter and also require assistance from my colleagues. Chair, this is the application for maximum price from Sasol Gas. It is for the period of 1st July 2023 to 30th of June 2024. The summary of the application is provided on table 1 of the submission. Sasol Gas is applying for a maximum price that is adjusted on a quarterly basis. For the period of 1st of April 2023 to 30th of June 2023, the maximum price that Sasol Gas indicated there is 82.88 per gigajoule. And when we apply the escalation or the adjustment for the period of 1st of July 2023 to September 2023, the maximum price that Sasol Gas is applying for comes to 78.23. And when we further apply the adjustment again for the period of October to December 2023, the maximum price that Sasol Gas is applying for is 74.54. Chair, the reason why Sasol Gas in its application called it a notional maximum price for the period of 1st of April to 30 June is because of the fact that this maximum price is subject to the proposed adjustment factor. Sasol Gas is adjusting the maximum price in line with the contracts that it has with its supplier in Mozambique and also with Sasol Secunda. Each of the gas supply has a contract with an adjustment formula, and therefore the cost of gas reflected in the application is a weighted average cost of gas of acquisition. Chair, on top of that, Sasol Gas is also applying for the trading cost element, and it's provided for on page table 1 of the submission. So we want to highlight the fact that Sasol Gas does not agree with the cost plus methodology, as it believes that this methodology is not suitable for the South African content. The applicant submits that the price that is yielded by the cost plus will not enable it to invest in increasing the life of generating asset in Mozambique, and may be forced to wind down its investment in the gas industry. Extensive write-up is provided in this regard, and Sasol Gas is also stating that there is a risk and reward imbalance due to the application of the cost plus methodology. According to Sasol Gas, its preferred method is that of linking South African gas price to gas indices traded in global hubs such as Henry Hub, TTF. This is the methodology that was approved by NERSA in 2020. So it is of the view that 2020 methodology is the preferred one rather than the methodology of the cost plus that was approved in 2023. Chair, on another element that Sasol Gas has raised in its application is the alternative value compensation. Sasol Gas requires compensation for the margin erosion due to selling gas to external customers, and this is provided for in Table 8 of the submission. Chair, in terms of the NERSA assessment, we believe that our role in the determination of the maximum price is to mitigate for lack of competition in the pipe gas market. And we do this by imitating maximum price that would persist in competitive markets and also facilitating conditions for effective competition. It is for this reason that we believe that the cost plus methodology is really appropriate. And also we have done some research, and our research indicated that competitive benchmark has proven not to be practical at this stage in South Africa, as illustrated by recent surge in the international gas prices. Furthermore, jurisdictions where gas prices were linked to global hubs are now moving to cost plus or traditional oil-linked price. This research, it was done through the RAR department. And also our research also revealed that global hubs has not translated into increased investment. We believe that the cost plus is more practical and relevant approach at this stage until such time as customers will have access to and are able to import gas from international markets. We also did our own calculation as verification of the information that was submitted by Sasol Gas, and we are agreeing with the Sasol Gas calculation. The difference between ours and Sasol Gas calculations are less than 10%. And therefore, based on the practice that NERSA has always accepted a price that it has a margin of less than 10%, we believe that the calculation for Sasol Gas are acceptable. Chair, under Section 8 of the submission, we provided an assessment which shows that the maximum price applied for by Sasol Gas is not excessive. In summary, what we are saying in that Section 8 is that the level of margin that Sasol Gas is applying for is reasonable and will not compromise competitiveness and investment. In terms of the margin that Sasol Gas is applying for, it is around 30%, which we believe that it is acceptable, and based also on the benchmark that we have done with companies that are similar to Sasol Gas, we believe that the margin of 30% is along the acceptable standards. Also, in terms of the analysis on Section 8, the surplus that is calculated or yielded by our methodology allows for the distinguishing or the implementation of the distinguishing features as per Section 22 of the Gas Act. So we are asking for the committee to approve the recommendations that are on paragraph 14. Thank you, Chair.
Thank you, Ms. Makota. Members, thank you for the comprehensive introduction and highlighting all the key aspects of the application. Members, any comments, input, issues of clarity? Mr. Gumede, please go ahead.
Chair, firstly, I support the recommendation, but the one question I wanted to ask, the clawback that we referred to in terms of the first item, would that clawback, should that clawback have been applied for as part of this application, of this particular application?
Thank you, Mr. Gumede. Any other questions, members? If not, may you please respond, Ms. Makot?
Chairperson, in terms of the clawback, yes, that clawback should have been included as part of the application. Our requirements for clawback is that clawback should wait for the audited results, and based on the audited of the actual information, they include it as part of the maximum price. So it is correct that that clawback, in terms of the correct procedure, it should have been included as part of this application. However, the applicant has not included it, but it doesn't mean that they cannot apply for it as a separate application. They can apply for it separately, but it will be implemented. It may be implemented concurrently with the current application. Thank you, Chair.
Thank you. I guess that issue of the clawback relates to the earlier submission that we considered on that FY23 that they applied for in April, and then in May they then applied for this specific application. So they were considered concurrently. I guess that was the reason, maybe that the clawback was not applied for. But besides, I mean, their financial year end is 30th of June. So the audits and all of that would not have been ready at that stage. All right. Does it clarify your question, Mr. Gumede?
Chairperson, I am clarified. Thank you.
All right, thank you very much. All right, members, if there are no further questions, I would like to then take you to the recommendations from the team. The recommendations are on paragraph 14, on page 14. The Pipe Gas Subcommittee is requested to recommend to the energy regulator to approve the maximum prices calculated in table 1. Of this table. I see here we have the dates there. They might be wrong, Ms. Magoda. For the period 1st October 2023 to 31st December 2023. I don't know this quarter because we want to approve the maximum prices applied for. Is that an error, Ms. Magoda?
What Sasol Gas is applying for is for the 1 year, and that maximum price will be calculated on a quarterly basis. So we'll correct the date, yes.
Okay, for the adjustment, yeah, that's the confusion. All right. Okay, so that is the actual price, the maximum price, because the stakeholders wanted the exact price so that there is no room for sort of manipulation of the adjustment, so that the data is known as to how it's going to be adjusted. So that's what you see on table 1. And then there is also a table 2 based on the adjustment for another quarter. And paragraph 14.1.3. The PGS is requested to recommend that the energy regulator approves that the price be adjusted on a quarterly basis with 1 month lag in the implementation until 30 June 2024 as prescribed in the methodology, and to also approve that the maximum price are exclusive of VAT, and also that the date of the energy regulator's decision on this application becomes the effective date of the maximum price application for monitoring and implementation, that the licensee is required to apply for the next maximum price 4 months before the expiry of the currently approved price, and that a study be conducted separately by NERSA to deal with security of supply. I'm not sure about that one. Mr. Chokoma's advice on that one. We wanted to to sort of monitor and do some studies. But I was just not sure whether this must be in the actual decision of this application, or is something that maybe we can add in the for decision as part of the monitoring. That is the item 14.1.7. And then the last thing that is requested is the publication of the reasons for decision for this application. Members, I raised that issue deliberately because it was a forward-looking, but I'm not sure that if it's supposed to be right on the decision, maybe that paragraph 14.1.7, maybe it can be somewhere in the RFDs. That's why I'm highlighting it to members. Mr. Chokwe, can you clarify if we can? Is proper to add that part on the decision itself?
Chairperson, good morning, and good morning, colleagues. I must admit that I'm just going to be guessing, but I think from where I'm sitting, I think it should be on the part of the monitor rather than on the decisions, because I think on the decisions, there are many things that follow, Chairperson, and if we don't follow them through, then they fall into cracks. But I think members have a right to actually indicate how it should be. If I were to advise, I would say, let it just be on the other side. It be not on the decision. But I can as well be wrong, Chairperson. Thanks.
All right. All right, members, are you comfortable with that guidance, so that the decision is not read by SASOL as if it's an obligation on its part, unless we want to sort of create another part of the decision for that aspect, just to make sure that the resolution of the committee does not fall into cracks and that the team will be able to do that study. Any suggestions, members, on that particular one? All right, let me, Mr. Pugula.
Thank you, Chair. My suggestion would be that it is removed from this decision, because this is a decision on SASOL's pricing, and we can have it as a separate matter that is consequential from it being stated in the reasons for decision.
Yes. Okay. Thank you. All right. Thank you. All right, Mr. Mkiza, you support that?
Supported from my side. Thank you.
Thank you very much. So we're going to remove that item there, 14.17, and it's something that the team, it should be recorded in the resolution, something that the team must do, Mr. Dlamini, but it is removed from the list of items that form part of the decision. Members, I had already read out the decisions that are required. Are members happy then, by show of hands, that all of these matters are recommended for approval by the energy regulator? Thank you, Mr. Mkize. Thank you, Mr. Kumede. Thank you, Ms. Mpungose. Thank you, Mr. Pugula. Thank you, Advocate Sithole. I also support the recommendations, except that other item to be moved. All right. I see there are still two hands. Mr. Pugula's hand is still up, and Mr. Mkize.
Sorry, I've got finger troubles here. Thank you.
Okay. All right, Mr. Mkize. Okay, thank you. Members, we're now moving on to item number 8, which is the final assessment of the application by Transnet for its transmission tariff, transmission pipeline tariff for the financial year 2023, April 2023, up until March 2026. Please take the matter as read. Please highlight the key aspects of this application.
Thank you, Chair. The tariff application itself, it's an amended application. It was necessitated by the NERSA decision that took place on the 17th of May. Where NERSA did not approve Transnet's application. Subsequent to that, Transnet sent a new application, an amended application to NERSA on the 22nd of June. And the impact of this application was a decrease of 71% in terms of the tariff itself. The driver of this was the decommissioning costs that were subsequently not approved in the previous decision. However, the application itself, NERSA did its own assessment of the Transnet application, and the difference between the two calculations are within 10%, in line with the precedents from previous decisions. What also must be noted is that during the consultation phase, or prior to the consultation, NERSA had issues with the calculations of the depreciation from Transnet. Transnet subsequently has provided NERSA with a schedule of their additions and their useful lives, which NERSA has assessed and subject to the RRM audits, because obviously they currently are there are assumptions. NERSA would have accepted them subject to that. I think, Chair, in a nutshell, we have accepted the application, given that the average tariff across the FY24 to FY26 is within the 10% difference, which is a precedence that NERSA allows. So we recommend as per section 14. Thanks, Chair.
Thank you very much. Members, the application is before you if you have any questions of clarity or guidance. Any questions of clarity? I think, members, what I can just emphasize is the importance of, because it's pretty close if you look at the calculations. Yes, we usually look into that difference of a double digit. So if it's within that and it's not tantamount to us setting the tariff, but we can, in terms of section 4H, we can monitor and regulate the tariff. So I think that will be important, and these aspects will also be looked at carefully during the audits when NERSA sends the licensee, to make sure that the auditors are going to pay particular attention on these areas during the RRM's specific audits that are conducted on an annual basis, and then also the monitoring of the tariff. It will be done in terms of section 4H to provide the reports to the energy regulator, just to monitor this very closely. So that is the other aspect that needs to be emphasized. With that, members, are you then happy to recommend the tariffs, the tariff application by Transnet for the period 1st April 2023 until March 2026, and also the publication of the RFDs by the energy regulator for approval? Those two decisions, members. By show of hands, members, if you approve. Thank you, Mr. Gumede. Thank you, Mr. Mkhize. Advocate Sithole, thank you. Thank you, Ms. Mpongose. I also support. Mr. Pukula, are you happy to recommend for approval by the energy regulator? Thank you, Mr. Pukula. Thank you, members. Members, we have come to the end of the open part of the meeting. I would like to thank stakeholders that were following the proceedings of this meeting. We are going to stop the live streaming at this point in time. Thank you so much for showing interest in NERSA's business. Mr. Mateja, can you please inform us